The first thing I noticed wasn't the flashing red and blue lights. It was the sound of handcuffs clicking open. Not closing, opening. The deputy standing in front of me lowered his hand from his duty belt, looked past my shoulder, and his entire expression changed. A second earlier, he'd been speaking to me like I was another stubborn homeowner, refusing to follow HOA rules. Now his jaw tightened, as if someone had whispered a secret that rewrote the entire situation. Behind him, the president of the Maple Grove Estates Homeowners Association pointed directly at me from the sidewalk. "That's him," she shouted loud enough for half the neighborhood to hear. "He's been trespassing on HOA property for weeks. He refuses to identify himself, and he keeps telling everyone our rules don't apply to him." I folded my arms. "They don't," the crowd gasped. One neighbor actually laughed under his breath before quickly pretending he hadn't. The HOA president, Linda Carson, looked absolutely delighted that 2 sheriff's deputies had finally arrived. She straightened her navy blazer like she was preparing for a press conference. "You've heard him," she said confidently. "He's admitted it. I'd like him arrested before he damages anything else." Deputy Mark Ellis turned toward me. "Sir," he said calmly, "this is your last opportunity. Either provide proof that you're authorized to be on this property, or we'll have to remove you." I reached into the inside pocket of my jacket. Linda smiled. "So he's finally giving up?" I ignored her. Instead of pulling out an ID, I removed a thick manila envelope, secured with a red county recorder's seal. Deputy Ellis frowned. "What's that?" "The reason this conversation is about to become very uncomfortable," Linda rolled her eyes dramatically. "Oh, please." She stepped closer, pointing toward the row of elegant brick townhomes lining both sides of the street. "This entire block belongs to the association. Every sidewalk, every parking area, every common space, every inch." I looked at her for a long second. Then I asked one simple question. "Who told you that?" She blinked. "Our developer." "The same developer who sold these homes?" "Yes, the same developer who went bankrupt 3 years ago." Her confidence flickered for the first time. Deputy Ellis looked between us. "Sir, what exactly are you saying?" Without another word, I handed him the envelope. He opened it carefully. Inside were certified warranty deeds, county tax records, recorded plats dating back decades, a title insurance policy, and one document sitting on top, in bold black letters. "Owner of record, Harrison Whitaker, my name." Deputy Ellis stared at the page. Then he turned another, and another. His eyebrows climbed higher with each document. "What?" he whispered. Linda leaned over impatiently. "What is it?" He didn't answer. Instead, he looked down the street, then back at the paperwork, then slowly spun in a full circle, taking in every townhouse, every landscaped island, every parking lot, every strip of grass that Linda had proudly claimed belonged to the HOA. Finally, he looked at me. "Are these certified copies for all of it?" I nodded. "The entire block." Silence. The crowd that had gathered moments earlier suddenly stopped whispering. Even the children riding bicycles nearby had frozen to watch. Linda snatched one of the documents from the deputy's hands. Her eyes scanned the first page, then the second. "No," she shook her head violently. "No, that's impossible." "It was recorded 11 years ago," I replied evenly. "Long before your HOA board was elected." Her face turned pale. "Our attorney would have known." Apparently he didn't. She backed away, as though the paper itself had burned her fingers. "This has to be fake." Deputy Ellis immediately took the documents back. "Ma'am, these carry official county recording seals." "I don't care what they carry." She pointed at me again, but this time her hand wasn't steady. "He told us he wasn't under the HOA." "I did. He ignored every violation notice. I returned every single one unopened. You refused to pay over $60,000 in fines because none of them were legally enforceable." One of the deputies quietly stepped aside and spoke into his radio. His tone had changed completely. Whatever confidence the HOA board had walked in with was evaporating by the second. Then the radio crackled back. The dispatcher's words were just loud enough for everyone standing nearby to hear. And the instant Linda heard them, the color completely disappeared from her face. The dispatcher's words echoed through the quiet street. "County records confirm the ownership documents appear valid. Registered owner of parcel group 14B through 14J is Harrison Whitaker. No one spoke. Not the deputies, not the neighbors. Certainly not Linda Carson. She stood perfectly still, staring at me as though I had somehow rewritten reality in front of her. Deputy Ellis finally cleared his throat. "Mr. Whitaker, I think we're going to need a much longer conversation." I gave him a small nod. I've been waiting almost 8 months to have it. 8 months earlier, life had been wonderfully uneventful. I'm Harrison Whitaker, 46 years old, a commercial real estate investor based in Franklin, Tennessee. Unlike the image most people have of investors chasing skyscrapers and luxury developments, my work has always focused on forgotten properties. The places everyone overlooks because they're complicated, tangled in old records, or simply not glamorous enough to attract attention. My father used to tell me, the most valuable land is often the land nobody bothers to understand. He spent 35 years as a county surveyor, walking fence lines, studying century-old plats, and settling boundary disputes before they ever reached a courtroom. Growing up, my weekends weren't spent on baseball fields. They were spent hiking through overgrown property lines, while Dad explained why a single iron pin buried in the dirt could determine the fate of millions of dollars. Back then, I thought it was boring. Years later, it became my career. The block at the center of this mess wasn't something I inherited. I bought it, quietly, legally, and with a mountain of paperwork. 11 years earlier, a regional developer had assembled several old commercial parcels into what was supposed to become a mixed-use shopping district. Then the housing market shifted, financing collapsed, and the company began selling pieces of the project to stay alive. Most buyers only looked at the finished townhomes. I looked at the original plats. Hidden between pages of legal descriptions was something almost everyone missed. The roads, landscaped islands, guest parking areas, sidewalks and utility corridors surrounding one entire block had never been transferred into HOA ownership. They remained under a separate holding company. When that company dissolved during bankruptcy, the property became available through a court-supervised liquidation. Almost no one noticed. I did. After months of title research, environmental studies, and conversations with county officials, I purchased every remaining parcel. It wasn't a flashy investment. In fact, my accountant questioned whether it made any sense. "What exactly are you planning to do with sidewalks and landscaping?" he'd asked. I smiled. "I'm planning to own them," he laughed. I wasn't joking. The property generated modest income through utility easements and future redevelopment potential, but I never intended to disrupt the residents. People had built lives there. Families walked their dogs every evening. Children rode bicycles around the landscaped loop. Retired couples gathered on benches beneath old oak trees. I had no interest in changing any of that. My philosophy was simple. Good ownership is often invisible. So I left everything exactly as it was. For nearly 10 years, nobody contacted me. Property taxes were paid. Insurance remained current. Routine maintenance contractors handled landscaping. Life moved on. Then Maple Grove Estates elected a brand new HOA board. Everything changed within weeks. The first letter arrived in a crisp white envelope with bold blue lettering across the top. Notice of violation. According to the board, I had failed to obtain HOA approval before replacing several decorative light fixtures along the sidewalks. I read the letter twice, then laughed, not because it was funny, because I honestly believed it had been mailed to the wrong person. I called the number listed anyway. A cheerful administrative assistant answered. "Maple Grove Estates, HOA. I think you've made a mistake," I said politely. "You've sent me a violation notice for property your association doesn't own." There was a brief pause. "Sir, all common areas belong to the HOA. I'm looking at my recorded deed. Our records say otherwise. I'd be happy to email you copies." "That won't be necessary." The confidence in her voice caught my attention. It wasn't arrogance. It was certainty. Someone had convinced this entire office that ownership was beyond question. A week later, another violation notice appeared, then another, then invoices, late fees, interest, administrative penalties. By the end of the second month, the board claimed I owed over $12,000. I mailed every envelope back unopened, not out of spite, out of principle. If I acknowledged authority they didn't legally possess, even accidentally, It could complicate future disputes. Then one quiet Saturday morning, while walking the property with my maintenance supervisor, I noticed something that stopped both of us cold. Fresh metal posts had been driven into the ground overnight. Workers were unloading brand new signs from a truck. One of them lifted the first sign into position. As the protective plastic came off, I read the words from 50 feet away. Private HOA property. Unauthorized access prohibited. I felt a knot tighten in my stomach because they hadn't just put those signs on land I owned. They'd done it after someone had clearly told them they had every legal right to do so. And that meant this wasn't just an administrative mistake anymore. Someone was acting with absolute confidence, and that confidence had to be coming from somewhere. I stood there for several seconds, staring at the freshly installed sign. The maintenance crew didn't seem nervous. They weren't sneaking around or working in a hurry. They were laughing with each other, drinking coffee, and following a layout map clipped to a clipboard. Whoever hired them had made them believe this was just another routine Saturday job. I walked toward the foreman. "Morning," he smiled politely. "Morning. Who's managing this project?" "The HOA. I looked at the sign again. "Did they tell you who owns the land you're installing those on?" His smile faded just a little. "They said it's association property." "It isn't." He shifted his weight. "I'm just following the work order, sir." "I understand." I wasn't angry at him. Contractors rely on the information they receive. If a client hands them a survey and says, "Install signs here," they generally assume the paperwork is legitimate. "I'd appreciate it if you'd stop until ownership is verified." He rubbed the back of his neck. "I can't do that without authorization." Before I could answer, a white luxury SUV rolled into the parking area. The driver's door swung open. Out stepped Linda Carson. Even from a distance, she carried herself like someone who expected every conversation to end in her favor. Perfectly pressed clothes, designer sunglasses, clipboard tucked under one arm. 3 other board members followed behind her. One of them, a tall man in his 60s wearing a golf shirt embroidered with the HOA logo, pointed toward me. "That's him." Linda walked directly up to me. "So," she said with a smile that never reached her eyes, "you're finally here." "I own the property. I tend to show up." She ignored the comment. "Our contractors informed us you've been interfering with scheduled improvements." I asked them one question. "You instructed them to stop working." "I informed them they're standing on private property." She let out a short laugh. "You really believe that, don't you?" "I don't have to believe it." I reached into my folder and pulled out a certified survey. "It's recorded." She didn't even glance at it. Instead, she folded her arms. "Our attorney has already reviewed ownership. I'd love to know what documents he reviewed." "The governing documents. Those aren't deeds. They establish HOA authority only over property the HOA actually owns." For the first time, irritation flashed across her face. "You've become a problem, Mr. Whitaker." "I've become inconvenient." One of the board members stepped forward. "We've received multiple complaints." "From whom?" "Residents." "What complaints?" "That you're creating confusion." I looked around. Several homeowners had wandered outside. After hearing the conversation, an elderly couple stood beside their mailbox. A young father pushing a stroller had stopped halfway down the sidewalk. Everyone was watching. "I haven't spoken to your residents," I said. Linda answered immediately. "You've refused to comply with community standards." "I've refused to surrender property rights." "Same thing." "No," I replied quietly. "Those are very different things." Her smile disappeared. She turned toward the contractor. "Continue installing every sign." The foreman hesitated. "Ma'am," she raised her voice. I said continue. The crew exchanged uncertain looks before picking up their tools again. I took out my phone. Linda noticed immediately. "Who are you calling?" "My attorney," she laughed. "Go ahead." "I intend to. And while you're at it," she said, "tell him the HOA is issuing an emergency enforcement action." I frowned. "Against what?" "You." "For what violation?" "Trespassing." I honestly thought I'd misheard her. "I'm trespassing on HOA common property that I own." She leaned closer. "You keep saying that because it's true. We'll let a judge decide." Within 48 hours, certified letters began arriving almost daily. Each one was more aggressive than the last. Unauthorized access, interference with association operations, failure to comply, property misuse, fines, legal fees, collection costs. By the end of the month, the HOA claimed I owed over $60,000. Then they posted bright orange notices on every entrance to the block. Notice of restricted access. My own maintenance contractors were stopped by private security, hired by the HOA. Landscapers I had employed for years were turned away at the entrance. One irrigation technician called me from the gate. "They're saying if I go in, they'll have me arrested." That was enough. I contacted my attorney, Daniel Brooks, one of the sharpest real estate litigators in Middle Tennessee. After reviewing the first stack of documents, he leaned back in his chair. I've handled boundary disputes for 20 years, he said. I've never seen an HOA this confident while standing on such shaky legal ground. So what are they missing? He tapped the deed. I don't know yet. His expression grew serious. But I do know this. He slid one of the HOA's legal notices across the desk. They aren't bluffing anymore. The association had voted unanimously to authorize law enforcement assistance for the removal of any unauthorized individual found on HOA-controlled property. That unauthorized individual was me. And for the first time since this ordeal began, I realized this wasn't simply a neighborhood dispute over paperwork. Someone, whether it was the HOA, their attorney, or someone connected to the original developer, was willing to involve the police to defend a claim that could collapse under a single certified deed, which raised a question that refused to leave my mind. If the truth was so easy to verify, why was someone working so hard to keep it buried? Daniel Brooks didn't answer my question right away. Instead, he closed the file, leaned back in his chair, and stared at the ceiling for several seconds. Whenever Daniel got quiet, it usually meant he was putting pieces together. Finally, he looked at me. Harrison, I don't think this case is about fines. I figured that much. I don't even think it's about the HOA. I frowned. Then what's it about? He slid the county plat map across his desk until it stopped in front of me. Look at the utility corridor. I studied the map. The roads, the landscaped islands, guest parking, sidewalks, stormwater easements. Everything looked exactly as I remembered from when I bought the property. I've looked at this map 100 times. I know. So what am I missing? Daniel picked up a red pen. Without saying a word, he circled a narrow strip of land running beneath the center of the block. It wasn't much wider than 20 feet. It carries water and fiber lines, and it also connects every townhouse in the neighborhood to the city's main infrastructure. I looked up. So whoever owns this strip controls every legal access agreement attached to it. The room suddenly felt quieter. Daniel wasn't exaggerating. He never did. If someone wanted to redevelop this neighborhood 10 years from now, he continued, they couldn't touch a single inch without negotiating with whoever owns these parcels. I slowly looked back down at the map. Me. I owned every one of them. Daniel folded his hands. That's not the kind of mistake experienced real estate lawyers usually make. So either they're incompetent or someone never showed them the complete chain of title. The next morning, we drove to the Williamson County Register of Deeds. I'd spent enough time there over the years that several employees recognized me. A senior records specialist named Melissa greeted us with a smile. Harrison, haven't seen you in a while. I wish this were a social visit, she laughed. Those are usually expensive. You have no idea. After explaining the situation, Melissa disappeared into the archive room. 15 minutes later, she returned, pushing a cart stacked with oversized record books, subdivision plats, bankruptcy filings, and transfer documents. I pulled everything connected to Maple Grove Estates. Daniel adjusted his glasses. Everything? She nodded. Back to 1989. For nearly 4 hours, we reviewed document after document, original development applications, planning commission approvals, bank loan agreements, construction permits, bankruptcy filings, property transfers. Most of it confirmed exactly what we already knew. Then Daniel stopped turning pages. He stared at one document without speaking. What is it? I asked. He didn't answer. Instead, he handed me the file. It was an assignment agreement executed just 8 months before the HOA first contacted me. The signature belonged to the bankrupt developer's former vice president. According to the document, the company claimed it had transferred all remaining common areas to the HOA for $1. I blinked. That's impossible. It should be. They didn't own the property anymore. Exactly. I immediately flipped to the recording information. There wasn't any. No county stamp. No recording number. No official filing. Just signatures. Daniel looked at Melissa. Did this document ever get recorded? She checked her computer. No. Not even rejected. She shook her head. There's no record of it ever being submitted. So legal, it never transferred anything. I leaned back in my chair. Then why would someone draft it? Daniel's expression hardened. To convince people it happened. That afternoon we visited the county planning department. Retired surveyor Frank Holloway happened to be consulting there twice a week after spending nearly 40 years resolving boundary disputes. When he heard which subdivision we were investigating, He smiled knowingly. I've been waiting for someone to ask about Maple Grove. Daniel and I exchanged a glance. You've heard of it, Frank chuckled. I drew half the correction surveys for that development. He spread a large aerial map across the conference table. Then he pointed to the exact parcels I owned. The developer tried to transfer these before bankruptcy. They couldn't, I said. They'd already pledged them as collateral to the lender. So the transfer failed? Frank nodded. The bank foreclosed first, and the bankruptcy court later sold the parcels. To me, he smiled. To you. Daniel leaned forward. So how could an HOA believe they owned all this? Frank hesitated. Because someone kept handing each new board the same incomplete file. What file? The developer's closing binder. I frowned. Missing what? Frank reached into his worn leather briefcase. I kept copies of my correction surveys. He unfolded a yellowed sheet, nearly 3 feet wide. Bright red handwriting covered the margins. Across the bottom was a notation, signed by the county engineer nearly 12 years earlier. Parcels 14B to 14J, excluded from HOA conveyance. I felt my pulse quicken. Linda's board had never seen this. Neither had their attorney. Neither, apparently, had anyone elected to the HOA over the past decade. Frank carefully folded the survey again. I always wondered why no one ever asked for these. Daniel looked at me. They weren't hidden. They were ignored. As we gathered our documents to leave, Melissa hurried into the room holding another file she'd just found in an unopened archive box. Harrison. She looked genuinely surprised. I think you need to see this. She placed a sealed envelope on the table. The return address belonged to the original developer's law firm. The envelope had never been opened. It was addressed to one person, Linda Carson. For several seconds, none of us touched the envelope. Melissa looked from Daniel to me, then back again. It was mixed in with archived subdivision correspondence, she said quietly. The box was mislabeled years ago. We only found it because we were pulling every file connected to Maple Grove. Daniel studied the front of the envelope without moving it. Postmarked? Melissa pointed to the upper right corner. 9 months ago. 9 months. Almost exactly 1 month before the first violation notice had shown up in my mailbox. I looked at Daniel. If it's addressed to Linda, can we open it? He shook his head. Not unless she authorizes it or a court orders it. So we leave it sealed. Exactly. He smiled slightly. And sometimes a sealed envelope is even more valuable than an opened one. I raised an eyebrow. How? Because nobody can accuse us of altering what's inside. Over the next 2 weeks, Daniel built our case with the patience of a master chess player. He wasn't interested in dramatic speeches. He wanted facts. Every document was indexed. Every survey was cross-referenced. Every tax payment I had made over the past 11 years was matched with county receipts. We obtained certified copies of every deed in the chain of title. We collected photographs showing my maintenance contractors caring for the landscaping long before Linda's board took office. Invoices, insurance policies, utility agreements. Everything pointed to one unavoidable conclusion. I had openly owned and maintained the property for more than a decade. Meanwhile, the HOA had never paid a single property tax bill on any of it, not once. Daniel placed the records side by side. Harrison, this is devastating. For them, for anyone claiming they believed they owned the property. Then, another surprise arrived. An anonymous email landed in Daniel's office. No signature, no identifying information. Just 3 scanned pages. The subject line read, "You didn't get these from me." The documents appeared to be minutes from a closed HOA executive meeting held 6 months earlier. One paragraph immediately caught my attention. Board advised that parcel ownership remains unresolved. Council recommends delaying title verification until redevelopment negotiations are complete. I read the sentence twice. Then a third time, Daniel looked at me. They knew. They suspected. Close enough. The next paragraph was even worse. Formal verification may interfere with pending discussions involving commercial acquisition opportunities. Commercial acquisition. I immediately remembered what Daniel had said about the utility corridor. Someone wasn't fighting over landscaping. They were positioning themselves for future development. If the HOA convinced everyone it already controlled the land, any developer interested years later would negotiate with them instead of me. The entire dispute suddenly made sense. It had never been about flower beds or sidewalks or violation notices. Those were pressure tactics. The real prize was ownership, or at least the appearance of ownership. Linda must have realized the situation was slipping away because the attacks became personal. Residents received flyers accusing me of planning to bulldoze the neighborhood. Social media posts claimed I intended to build apartment towers. Anonymous comments called me a corporate land baron. One evening, I walked into a local coffee shop. The conversation stopped. A woman I'd never met looked directly at me. "You're the guy trying to take our homes," I answered calmly. "No, ma'am. I've lived here 18 years. So have many good people." "Then why are you suing us?" "I'm not suing the residents," she hesitated. "I'm asking a court to determine who owns the property." Her expression softened just a little. "That's not what we've been told." "I know." The pressure escalated again 3 days later. I arrived at one of my maintenance storage units to find every lock glued shut. Spray paint covered the loading door. Across the metal in huge black letters, someone had written, "Leave our neighborhood." The sheriff's office documented the vandalism. Security cameras captured 2 masked individuals arriving just after midnight. The images weren't clear enough for identification, but one detail caught the detective's attention. The pickup truck they used carried temporary magnetic signs. The logo belonged to a landscaping company under contract with the HOA. No arrests were made. Not yet. 2 mornings before trial, Daniel called me into his office. Every trial exhibit sat neatly arranged in numbered binders. Large aerial maps leaned against one wall. Certified surveys covered another. The courtroom presentation was ready. Daniel handed me a final exhibit. "What am I looking at?" "The county tax payment history." "I've seen it. Look closer." Across 11 consecutive years, every tax payment had been accepted by the county without dispute. No objections, no competing ownership claims, no challenges from the HOA. Daniel smiled. "They spent years pretending you didn't own the land. And? The government spent 11 years treating you like the owner." He closed the binder. "Harrison, for a jury, that would be persuasive. We don't have a jury." "No." He looked toward the courthouse visible through his office window. "We have Judge Rebecca Holloway." I'd heard her reputation. Methodical, patient, unimpressed by theatrics. She cared about documents, not emotions. Daniel gathered the final box of evidence. "I've tried property cases before Judge Holloway. How does she handle people who exaggerate?" His smile widened. "They usually regret it." As we walked toward the courthouse the following morning, television news vans were already parked outside. Someone had leaked the case. Reporters stood on the courthouse steps, interviewing Maple Grove residents. Across the plaza, Linda Carson climbed out of a black SUV with her attorney. She looked confident until her eyes met mine. Then she noticed the 4 bankers' boxes our legal team was carrying. Her smile faded. For the first time since this nightmare began, she looked like someone who was beginning to wonder whether she had walked into the wrong courtroom. The Williamson County Courthouse always had a way of making people lower their voices. Its polished marble floors reflected the morning light pouring through the tall windows, and every footstep echoed just enough to remind you that important decisions had been made there long before you arrived, and would continue long after you were gone. By the time Daniel and I entered Courtroom 3, nearly every seat in the gallery was occupied. Residents from Maple Grove Estates filled the benches. Some looked curious. Others looked nervous. A few refused to make eye contact with me altogether. At the front of the courtroom, Linda Carson sat beside the HOA's attorney, Michael Reeves. Gone was the confident smile she'd worn during our confrontations outside. She kept shuffling papers, whispering to Reeves, who looked increasingly irritated each time she interrupted him. At precisely 9 o'clock, the courtroom deputy announced, "All rise." Judge Rebecca Holloway entered without ceremony. She was known throughout the county for one thing above all else. She hated wasted time. After everyone sat, she looked over the case file. "Counsel, this matter concerns disputed ownership of several parcels within Maple Grove Estates." "Yes, Your Honor." Both attorneys answered almost simultaneously. Judge Holloway nodded. "Then let's determine who actually owns them." No speeches, no drama. Straight to the point. Attorney Reeves stood first. He spoke confidently, pacing slowly before the bench. "Your Honor, for more than a decade, Maple Grove Estates Homeowners Association has openly maintained these common areas for the benefit of every resident. The association has exercised continuous control, established community regulations, and reasonably relied upon representations made by the original developer." Judge Holloway interrupted. "Counsel, maintenance is not ownership." Reeves paused. "No, Your Honor." "Then show me a recorded deed." He blinked. "We intend to demonstrate equitable authority." "I asked for a deed." Silence. Reeves glanced toward Linda. She looked back with growing concern. Finally, he admitted, "We do not possess a recorded deed conveying the parcels directly to the association." Judge Holloway made a note. "Proceed." When it was Daniel's turn, he didn't move dramatically across the courtroom. He simply carried one binder to the podium. Your Honor, this case is not complicated. He placed the certified warranty deed before the judge. The defendant's name appears on every recorded transfer, beginning 11 years ago. Next came certified tax records, insurance policies, utility easements, county plats. One by one, no theatrics, just evidence. Daniel looked toward the witness stand. The plaintiff calls Melissa Grant. Melissa, the county records specialist, testified calmly. She explained how every transfer affecting the disputed parcels had been recorded. She described the county's indexing procedures. Then Daniel asked the question everyone had been waiting for. Ms. Grant, according to official county records, who owns parcels 14B through 14J? She answered without hesitation. Harrison Whitaker. Has ownership changed since the deeds were recorded? No. Has the Homeowners Association ever recorded ownership of those parcels? No. Reeves stood. Objection. On what grounds? Judge Holloway asked. The witness is offering legal conclusions. Judge Holloway looked at Melissa. Did you offer a legal conclusion? No, Your Honor. What did you offer? The county's recorded ownership history. Objection overruled. Next came retired surveyor Frank Holloway. He carried the original correction survey, rolled inside a protective tube. After taking the oath, he carefully spread the survey across a large display board. The courtroom leaned forward. Frank pointed to the bold red notation. These parcels were specifically excluded from HOA conveyance. Daniel asked, who made that notation? The county engineer. When? 12 years ago. Was that exclusion ever revoked? No. Reeves approached for cross-examination. Mr. Holloway, is it possible the developer intended to transfer these parcels later? Frank smiled politely. Intent doesn't transfer title, but they may have believed. Belief doesn't transfer title either. A few quiet chuckles spread through the gallery. Judge Holloway immediately looked up. This courtroom isn't a theater. The room fell silent again. Then came the moment Daniel had been saving. He asked permission to introduce one final exhibit, the sealed envelope addressed to Linda Carson. Judge Holloway studied it carefully. Has this envelope been opened? No, Your Honor. Where was it located? Melissa explained exactly how it had been discovered in the county archive. Reeves immediately objected. Irrelevant. Daniel shook his head. Not if it establishes notice. Judge Holloway considered both arguments. Then she looked directly at Linda. Ms. Carson. Linda slowly stood. Yes, Your Honor. Were you expecting correspondence from the developer's law firm approximately 9 months ago? Linda swallowed. I'm not sure. Judge Holloway picked up the sealed envelope again. The courtroom became so quiet that I could hear someone shifting in the back row. The judge turned the envelope over. Then she noticed something handwritten across the flap. Her expression changed, very slightly, but enough for Daniel to notice. Counsel, she said slowly. Approach the bench. Both attorneys walked forward. Their discussion lasted less than 2 minutes. Too quiet for anyone else to hear. When they returned, Reeves no longer looked confident. His face had gone pale. Daniel remained expressionless. Judge Holloway looked across the packed courtroom. I have one final question before this court recesses for 15 minutes. She fixed her eyes on Linda Carson. Miss Carson. Linda gripped the edge of the counsel table so tightly her knuckles turned white. Did your board continue issuing fines and requesting law enforcement intervention after receiving legal advice that the association might not own the disputed property? Linda opened her mouth, but before she could answer, her own attorney suddenly stood up. Your Honor, Reeves said quietly, I believe my client needs a moment to confer with counsel. The judge slowly removed her glasses. Her expression revealed nothing. Very well. She struck the gavel once. Court will stand in recess. The verdict and Linda's answer would have to wait. The courtroom buzzed with whispers the moment Judge Holloway left the bench. No one moved very far. The residents of Maple Grove remained glued to their seats, quietly exchanging confused looks. Reporters rushed into the hallway to update their producers. Camera operators adjusted tripods outside the courtroom doors. Inside, the atmosphere had completely changed. An hour earlier, I had been the man the HOA wanted arrested. Now every conversation revolved around one question. What had Linda known? Daniel leaned toward me. Don't react to anything. I'm not. Good. He glanced across the room where Linda sat with Attorney Reeves. Their conversation wasn't calm. Reeves had both hands on the table, speaking in a low but unmistakably frustrated voice. Linda kept shaking her head. Twice, she pointed toward me. 3 times, Reeves interrupted her. Finally, he pushed his chair back, walked several steps away, and rubbed both hands across his face. I'd seen attorneys lose difficult cases before. I'd never seen one look blindsided. 15 minutes later, the courtroom deputy called everyone back to order. Judge Holloway returned, placed her file on the bench, and looked directly at Attorney Reeves. Counsel? Reeves slowly stood. His shoulders had noticeably dropped. Your Honor, he paused. My client authorizes me to make a statement. The courtroom fell silent. The Homeowners Association acknowledges that the disputed parcels are not titled in the association's name. A collective gasp swept through the gallery. Linda closed her eyes. Reeves continued. Furthermore, after reviewing the evidence presented this morning, the association withdraws its claim of ownership. Judge Holloway looked toward Daniel. Mr. Brooks, Daniel stood. We appreciate the concession, Your Honor. However, ownership was never the only issue before this court. Judge Holloway nodded. I agree. She turned another page in her notes. The court must also address the association's enforcement actions. Judge Holloway spent nearly 20 minutes reviewing the timeline. Her voice never rose. She simply walked through the evidence, one fact at a time. The association issued violation notices. She turned a page. Demanded payment exceeding $60,000. Another page. Restricted access. Another. Requested law enforcement assistance. Then she looked directly at Linda Carson. All without verified ownership. Linda stared at the table. Judge Holloway continued, this court finds that the association failed to perform even the most basic title verification before asserting authority over property belonging to another party. She paused. That failure was unreasonable. Another pause. It was avoidable. Then came the sentence I'd waited nearly a year to hear. The court declares Harrison Whitaker the lawful owner of parcels 14B through 14J and permanently enjoins Maple Grove Estates Homeowners Association from exercising authority over those parcels. I closed my eyes for just a second, not because I doubted the outcome, because hearing the words out loud felt completely different from reading them on paper. Judge Holloway wasn't finished. She ordered every violation notice issued against me to be declared null and void. Every fine, every penalty, every collection action, gone. She ordered the HOA to remove every unauthorized sign installed on my property within 10 business days. She prohibited the association from interfering with my contractors, vendors, or lawful use of the land. Then she addressed attorney's fees. The association's actions unnecessarily prolonged this dispute. She awarded me reimbursement for substantial legal costs. Several board members visibly slumped in their chairs, but the biggest moment came next. Judge Holloway looked toward the clerk. I am also directing that a copy of today's findings be forwarded to the office of the district attorney for review, regarding any potential misrepresentations contained in future enforcement actions. The courtroom erupted, not loudly, just dozens of shocked voices all at once. The deputy immediately called for order. Linda looked as though she might collapse. Outside the courthouse, television cameras lined the front steps. Microphones appeared the moment Daniel and I exited. One reporter asked the obvious question, Mr. Whitaker, do you have anything to say to the HOA? I looked back at the courthouse before answering. This was never about beating my neighbors. I could see several Maple Grove residents standing nearby. Some offered small, apologetic smiles. Others looked embarrassed. It was about protecting the truth. Another reporter stepped forward. Are you planning to close access to the roads or sidewalks now that ownership has been confirmed? I shook my head immediately. No. But you legally could. I could. Will you? I smiled. My neighbors didn't create this problem. That answer spread across local news that evening. Over the next several days, something unexpected happened. Residents started knocking on my door, not to argue, to apologize. An elderly couple brought homemade cookies. A retired teacher admitted she'd believed every rumor the HOA circulated. One young father introduced himself and simply said, I'm sorry we judged you before knowing the facts. I accepted every apology, because most of them had been misled just as much as anyone else. Within 2 months, Linda Carson resigned as HOA president. 3 other board members stepped down shortly afterward. The association hired independent legal counsel to review every policy, every governing document, and every property record before taking further enforcement action. Their first recommendation was simple: verify ownership before claiming authority. As for me, I kept the property exactly as I always had. The sidewalks stayed open. The landscaping remained maintained. Children still rode bicycles around the block every evening. Nothing looked different. Except one thing. Every unauthorized HOA sign had disappeared. And every time I walked those sidewalks after the case ended, I was reminded of a lesson my father taught me years ago, while standing beside an old property marker. Land doesn't care who speaks the loudest. It belongs to whoever can prove it. Several months have passed since the judge's ruling, and life on the block is quieter than it's been in years. Most evenings I take the same walk around the sidewalks that caused so much controversy. Kids still race their bikes around the corners, neighbors still stop to chat by the mailboxes, and the oak trees still cast long shadows across the brick walkways. Looking at the neighborhood now, you'd never guess it was once the center of a courtroom battle that nearly ended with me being arrested on land I legally owned. The experience changed the way I think about property rights and about people. Documents matter, but so does integrity. Too many conflicts begin because someone assumes authority without taking the time to verify the facts. If there's one lesson I hope others take from my story, it's this: never confuse confidence with truth. The loudest voice in the room isn't always the one that's right, and a single verified document can outweigh 1,000 unsupported claims. Thank you so much for watching and spending your time with me. If you've ever dealt with an HOA, a property dispute, or a situation where someone abused their authority, I'd genuinely love to hear your experience. Here's my question for you. If you were in my position, would you have kept the sidewalks open after everything that happened? Or would you have closed access and enforced your ownership rights? If you enjoyed this story, please like the video, subscribe to the channel, and turn on notifications so you don't miss future stories of justice, property rights, and unbelievable HOA battles. Until next time, remember, the truth may take time to surface, but when it's backed by facts, it has a way of standing its ground.